It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And last week, huge news dropped for everyone, not just fight fans, but the FTC ruled that non-competes are no longer legal. So, John, before I ask you how you're doing, I gotta ask you, is that the most tremendous news ever or what?
It's up there. It's big news. I mean, we'll have to wait and see. I dread to see what these courts do, some of the justices, but it's huge news especially if it's allowed to stand.
Now, let's back up for a moment because you said, I dread to see what the courts do. Now, we both know that a couple of suits have already been filed in Texas, and we kind of have a good idea why, because it's really easy to judge shop here. But let's talk about why you worry, because isn't Lena Khan completely within her bounds to do this?
It would seem, if you look at the FTC rules, the rules that they're the precedent that they're using, and you look at the rules that give the FTC powers, Section 5 and Section 6, it seems pretty clear that they have the power to make laws that allow them to do their job, which is to oversee, basically commerce and to prevent violations of commerce and monopolization of the market and abuse of it, right? So this would seem to apply. It also, just on a pure pro-American point of view, this is a negative action being taken by the government, not a positive. What I mean by that is all they're saying is we are not going to do something. They're not saying you have to do something. They're not forcing companies to do something. What they're doing is saying we, the government, we are not going to enforce at all non-compete contracts, in non-compete clauses in contracts, because it's not in the interest of our citizens, our commerce, our country for us to do that. And I kind of fall on the side of that side because I think they are terrible for most people, right? It's an abuse of power by people higher up to force these on their workers. And so I agree with that. So to me, it's always strange that the small government conservatives are like, oh, the government's pushing themselves into business. Well, this is actually pretty small government, because the government's saying, you cannot use the power of the government. We will not do anything to enforce these actions. So I think this is a smaller government action, but hey, that's just me.
How about the non-competes that MMA contracts have?
Well, they don't come on. They're not called specifically non-competes, but I did call around, and I don't know if I'm not going to say the people's name because I didn't get permission to use their names, and some of them are a little hesitant, I guess, to interact with the MMA fan base, but for whatever reason.
Wait, before you mention it, could I ask you one thing really, really quick?
Yeah.
You said that the language isn't, not for contracts, for MMA contracts, the language isn't non-compete. But if you were to look at this just from John Nash's viewpoint, are they non-competes?
Well, that's the question, because you read the definition of non-competes that the FTC gives, and it's basically any contractual provision that's there to prevent you from taking offers from someone else once your contract's up. Then you're like, well, that's questionable. That sounds like a lot of these common MMA fighter contracts. Now, obviously, what Scott Coker had when they bought Strikeforce, the UFC, that's a non-compete. There are non-competes in MMA, but the ones I think might be covered of this are specifically the exclusive negotiating period, when your contract's up and you can only talk to one promoter from anywhere from a month to 3 months, right? Or 4 months, that every contract seems to have is the exclusive negotiating period. That seems to fall under the definition of non-competes that the FTC gives, which is that, a contract that prevents you from taking offers from someone else once your agreement's done. Or I should say provision in a contract that forbids you from taking offers once your agreement's done. That seems to fall in that. It's talking to people, kind of legal experts and attorneys and stuff and contract guys. The other ones that like they could fall under this, that could be challenged and fall under this provision, this ruling by the FTC, and these provisions might be outlawed under it, would be possibly is the right to match, right? Because that seems designed to prevent you from going somewhere else. That's a possibility. And then or also prevents you from taking straight up just, offers from anybody, because as soon as you offer and agree, you can't get a bidding war under right to match. You agree, and then they can match. So that would be one possible that could fall under it. And then also the champions clause could potentially, that's probably would be the farthest reach, but that potentially could fall under a non-compete, even though you were paid under the championship clause. So it sounds more like an option extension. Looking at it, it seems the intent is that your contract's up and we don't want you to leave while you're champion. And so that could possibly be classified as a non-compete. So those three, especially the exclusive negotiating period, seems like there are possibilities that they would fall under this non-compete band.
Let me ask you this. Has there been any rumblings that you've heard that maybe somebody might be looking into this with attorneys, with help?
I mean, some managers are looking at it, but are they going to do anything about it? I don't know. The question too is, who would oversee and say that this is a violation of the non-compete rule? If it's the FTC, I've had two different people give me two different complete answers on this. So completely different answers. So if it's the FTC you go to, well, then it might be worth challenging, because then you basically set a precedent and you make all these tolling provisions the UFC have, and not just the UFC, I should say, in all MMA, because it'd be Bellator, or old Bellator, but PFL, one championship contracts in the US, all of them would no longer be valid. But it also could be that, like with the UFC and PFL and all these promotions and they all have arbitration now. So maybe you'd have to go to arbitration, which makes it a little probably people a little more hesitant to challenge it, because you'd go to arbitration, and arbitration might be more, lean towards the promoter. So it gets, it seems a riskier gamble if you want that. So I guess the question is, anybody challenging? I don't know any specific fighters challenging it yet. And that's always been the problem with a lot of stuff in MMA, because you talk to people and a lot of stuff in MMA seems patently like it would not be upheld in a court. But how do you find a fighter withstanding? In other words, a fighter that this impacts to come forward. In the past, it was, you could challenge the championship clause in court in the past if you were a person that the championship clause was being used on, right? That's how many fighters? One out of tens of thousands that happens to. So it's a very rare thing. So there's no one withstanding to challenge it. Now there's arbitration, so there's less chance of anybody challenging it. And now over the years, fighters seem less willing to challenge the promotions in court. So maybe the Bellator PFL merger and some of the frustration that's caused will lead to this, but to lead to someone using this to challenge it. But again, the first step we got to get through is, will it be upheld by the courts? Because it's already been challenged in the Texas district courts. We have to wait and see if that even holds up. And even though it looks like it has all the precedent in front of it, and the FTC has all the power to do this, there's no way to know what a federalist judge, which there's a lot of them now on the courts, are going to rule, because anything that big businesses doesn't like, well, federalist judges don't think are legal.
Even if this does go through the FTC, the way that you said at first would probably be the most effective, even then, there's still a very good likelihood that any progress made could get struck down in a federal court.
It's a very good chance. And my Isla here has now entered the chat. She's in the show, walking on my keyboard, so I might get muted any second. You got it. Okay, there you go. Yeah, there's a very good chance. And it's like, if people who follow American history remember the Lochner Court, which was the court that basically killed a lot of the efforts in the progressive era, and it took decades to undo the damage they did. It very well could be we are entering a new Lochner Court, because not only are the courts, one of these cases, challenging this ruling by the FTC that they don't have the power to do it, they're also challenging the FTC itself and claiming it's unconstitutional.
Yeah. And
there's also the case going on with the NLRB. Well, several companies are claiming the NLRB is unconstitutional.
And they have a lot of weighty people behind that one. Elon Musk, Amazon, Starbucks, Trader Joe's. I mean, that's a whopping lot of money sitting right there that's just funding lawyers nonstop to fight this thing.
Every major company that's afraid that unionization is coming their way is spending a lot to say that the NLRB has no power.
Yeah. Wrap it up in a nutshell before we finish this little mini-sode.
That the FTC has issued a ruling that's going to have immense benefits to most, not just to most, but a lot of American workers. Supposedly 20% of all workers have a non-compete, even people that should never have non-competes, like fast food workers and people in, hospitals. Just they have a whole page of people gave their own, sent in messages of their own testimony, their own dealing with non-competes, and just read these kind of just terrible stories of how they've ruined lives. So the FTC has made a ruling which could be just great for masses of the American public. Including could have some benefits to MMA fighters, and that's why we brought it up. But there's also a good chance that some federal judges, I guess they want to return to feudalism. I don't know what their viewpoint is, but they could knock this down because God forbid we do something that helps the average Joe.
Exactly. And the fact that they brought those cases to Texas really speaks volumes. And on that wonderful, wonderful, positive, uplifting note, we're going to wrap our tiny little mini-sode here. We hope you've enjoyed it. We hope you subscribe. That's how we can keep doing this. Do me a favor, follow this guy on Twitter. He's Hey Not the Face. His direct messages are open. Send him a suggestion, a comment, anything you'd like to say. Wide open. I'm Crooklyn MMA. You can do the same for me. Anything you share with me will get shared with John. On that fine note, we're going to wrap the show. Until next time, please stay safe.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!